Welcome to Spoken Injustice, where we put the criminal justice system in the dock. On the 18th of July 2024, the much anticipated report of Mr Henley KC into the Criminal Cases Review Commission's handling of Mr Malkinson's case was finally published, eliciting a variety of reactions. In this video, we will provide an overview of the report and discuss the immediate reaction following its publication, particularly from Mr Malkinson, the new Justice Secretary Shabana Mahmood, as well as the CCRC's chairman, Helen Pitcher. We will also examine whether this report could now serve as a basis for reconsidering the decision to make Mr Malkinson's inquiry statutory. As always, our goal is to provide you with the information you need to form your own opinion. Finally, we will conclude by sharing our perspective. First, allow me to make two preliminary points. One is that the consideration and analysis of this report will inevitably involve reference to the brutal attack that occurred in 2003, which undoubtedly has left the victim traumatized for life. In discussing the tragic events surrounding this matter, as always, we do not intend to cause any distress to the victim, her family and friends, to whom we extend our sincerest well wishes. Any reference to the attack will be kept to a minimum and mentioned only when necessary. The second preliminary point is that those who expected Mr Henley KC's report to be groundbreaking and conclude in favour of a complete overhaul of the CCRC will be highly disappointed. In fact, although Mr Henley KC is highly critical of the CCRC, he also acknowledges significant improvements in its operations, particularly noting the enhanced professionalism and depth of their recent work. This is reiterated in his recommendations, such as Recommendation H, which we will discuss in more detail later on in the video. Some argue, however, that those expectations were entirely unrealistic in any event, given that the report concentrated exclusively on Mr Malkinson's specific case and did not consider the broader caseload or the overall practices and policies of the CCRC. Therefore, while the findings offer valuable insights, they may not fully represent the overall performance or challenges faced by the CCRC. We bring this issue up now more to narrow our analysis rather than to address it immediately. We will revisit this point later on, so stay with us until the end for a more in-depth perspective. In fact, this brings us smoothly to our starting point. Let's begin by examining precisely the scope of the report. This is set out at page 2. First, Mr Henley KC sets out the background. He says Mr Malkinson's made 3 applications to the CCRC in 2009, 2018 and 2021. The first 2 applications were refused. The third application resulted in a referral back to the Court of Appeal in January 2023 and, as we know, ultimately a successful appeal hearing on the 26th of July 2023. Mr Henley KC says, my task is to review all work undertaken by the CCRC during their considerations of the 3 applications, the quality of the decisions made, the investigative strategies, and the length of time taken to reach conclusions. Specifically, he says, I'm asked to look at the decision not to obtain the police file, opportunities and decisions relating to DNA work, criticisms and concerns raised in the media, other observations, learning points and recommendations. Let's examine these points one by one. Note that purely for convenience, we will invert the order slightly and we will examine point 2 first. However, before we do so, we need to set out the context in which Mr. Malkinson's applications were submitted. As we know, the first application was submitted in 2009. A few years earlier, at the end of 2006, the Metropolitan Police came to know of a phenomenon related to DNA testing called inhibition, whereby contaminants or chemicals would cause the DNA profiling method to fail to produce a DNA profile and give a false negative result. The effect of any inhibition chemicals can be reduced by a procedure called dilution, which optimizes reaction conditions. The FSS started the process of dilution in 2005. Therefore, all cases tested before this date, including Mr. Malkinson's case, could have all been subject to inhibition. Following this discovery, Operation Cube was established, whereby a process of past samples re-examination commenced. In the case of Mr. Malkinson, the retesting of the cellular material extracted from the victim's vest top, prompted by Operation Cube in 2007, had produced a new and much improved DNA result, showing not only the presence of a DNA profile matching the victim, but also a searchable partial profile for another person. The source of this new DNA profile could not have been the victim's boyfriend or Andrew Malkinson, both of whose DNA profiles were compared to the new result and excluded as being the second contributor. The FSS went even further and in 2008 eliminated all possible identifiable alternative innocent sources of this new DNA profile, i.e. all those people who had come into recent contact with the victim prior to the offence or immediately afterwards. The database was searched, but not much was found. These findings, which were not initially shared with the CCRC, were eventually shared in July 2010. Even in light of the fact that no possible match was found, these were very important findings, especially given the significant location from which this cellular material was extracted, namely the victim's vest top, which was covered by hair fleas and therefore not easily accessible by accidental contact. Though it did not prove Mr. Malkinson's innocence per se, it cast serious doubt on his involvement and could have made a big difference to the verdict, given that at the time of the trial, the DNA profile from the same location was incomplete and contained very little information. At the time of the trial, in fact, it was believed that Andrew Malkinson could be the source of this DNA. However, the occurrence of this trace of DNA was estimated as 1 in every 2 individuals, so 50% of the population. On those basis, the jury was directed that the DNA findings could not be of any help and did not support the identification. So clearly, this was a major breakthrough. So having set the background, let's see what were Mr. Henley KC's findings. First, in relation to the opportunities and decisions relating to the DNA work. As we have already stated, the new DNA findings in 2008 were significant, and although not initially communicated to the CCRC, these were known by the CCRC from July 2010. It appears that nothing was done about these new findings by the first case review manager from 2009, when the first application was received, to 2011, when this case manager left and the case reallocated to a new case review manager. The case decision records contained an initial disconnected analysis of the case and thereafter only summaries of the various correspondence with the then legal representative of Mr Malkinson. The case review manager did not appear to take any action and eventually, as we said, left the CCRC in 2011 with no clear plan as to how to progress Mr Malkinson's case. So 2 years had gone by without any action plan, all the while Mr Malkinson was languishing in prison. The case was reallocated to a new case review manager in 2011. The history of the case review entries by this new case manager shows a total lack of understanding of the importance of the new DNA findings. The new case review manager eventually settles for refusal of Mr Malkinson's application on the basis of 3 factors. 1, the reluctance by the original forensic scientist used at the trial, who said to him in a telephone call that though further work can be commissioned, particularly from the scraping of the left fingernail with which the victim asserts to have scratched the assailant, she will not be confident that a re-examination of the material will lead to the recovery of a profile sufficient for comparison on the DNA database. The second factor was the reluctance of another forensic scientist who conducted the original test on the scraping from the right fingernails, who stated that the fingernail scrapings rarely provide anything other than the donor's profile. And 3, the strength of the identification evidence purely taken for granted on the basis of the assertions of the Court of Appeal, which deemed these compelling during Mr Malkinson's first appeal heard in 2006. These facts were not established through careful consideration or meeting with the experts, but rather through casual telephone conversations and from file notes. His provisional statement of reasons seems to have been rubber-stamped by the commissioner who made the final decision. He seemed to have approved it the day after having received it, with no further discussion or follow-up. We understand that only one commissioner is needed to approve a decision not to refer, as opposed to 3 needed to decide to refer a case to the Court of Appeal. Mr Henley KC was unable to question the commissioner in question, who has since left the CCRC, could not remember the case, and was not keen to speak to him. The core of the final statement of reasons in this first occasion, which was communicated to Mr Malkinson's legal representatives in February 2012, is contained in paragraphs 48 and 49, in which it is ultimately concluded that as the new DNA evidence was not capable of identifying a genuine and reasonable suspect, it was not fresh evidence of sufficient force to overcome a strong Crown case which depended upon identification evidence. Although this view is clearly superficial and demonstrates a complete lack of understanding regarding the significance of the DNA findings from Operation Cube, having reached this conclusion, one would have expected an action plan to periodically revisit the case to check for any match, says Mr Henley KC. However, this was not done. Furthermore, Mr Henley KC tells us that another opportunity arose shortly after the refusal was communicated to Mr Malkinson. In fact, a few months later in 2012, the CCRC referred Nealon's case to the Court of Appeal. As we discussed in our video, Mr Malkinson Compensation and the ECHR, Mr Nealon's case was not dissimilar to Mr Malkinson. Both involved strangers' rape, and the convictions were based solely on identification, which the Court of Appeal in the first appeal deemed strong identification evidence. However, when the retesting of the victim's bra revealed DNA that did not match any innocent source of contact, including the victim's boyfriend and Mr Nealon himself, the CCRC decided rightly to refer the case to the Court of Appeal, despite the DNA profile not matching anyone in the database. The case was heard by the Court of Appeal in 2014, resulting in Mr Nealon's conviction being quashed. Shortly after, a case review manager re-examined Mr Malkinson's case in light of Mr Nealon's appeal and sought advice from a group leader on whether the outcome of Mr Nealon's case would now render the conclusion reached in Mr Malkinson's case redundant. However, the group leader determined that this was not the case. Once again, says Mr Henley KC, the error was made of not considering the significance of the location from which the cellular matter originated, nor the exclusion test that ruled out Mr Malkinson and all other innocent sources who had contact with the victim around the time of the attack. This could have been the moment that Mr Malkinson would have reasonably been freed and vindicated, but this opportunity was lost. Regarding the second application brought by Mr Malkinson's new legal representative's appeal in 2018, this was exclusively based on faults with the identification evidence. Therefore, we will examine this as part of Mr Henley KC's analysis of the reasons for not obtaining the police file. However, one point related to the DNA evidence can be made at this stage. Partway through the second application, Appeal requested the CCRC to pause the process as they were applying to the LAA for funding to conduct further forensic DNA testing. The CCRC refused to pause the application. Although Mr Henley KC found the refusal to pause justified and also that the CCRC had offered reasonable alternatives, he was equally critical of the CCRC for not taking this opportunity to collaborate with Appeal. The CCRC could have investigated why Appeal deemed further DNA testing necessary and worked with them to obtain it, or could have even rechecked the database for a match on the previously identified profile. As we know, a match at this stage would have identified the new suspect. Therefore, another opportunity was lost to finally vindicate Mr Malkinson's claims of innocence. The third and final application made by Appeal on behalf of Mr Malkinson came in 2021, presenting strong and compelling grounds that, as we know, eventually led to a referral. These included a report from a forensic scientist instructed by Appeal who used new DNA technique known since 2014. The scientist identified a searchable male DNA profile originating from key areas such as the vest top, scraping from the victim's left fingernail, the neck area, and the bra. That could not be Mr Malkinson's. Additionally, the application highlighted the police failure to disclose the previous convictions of the two independent identifying witnesses, some involving dishonesty, which was submitted as further ground for referral to the Court of Appeal due to its impact in the reliability of identification evidence. In response to this application, the CCRC conducted further testing to corroborate Appeal's forensic work and commissioned the comparison of the profile within the database, which this time, as we know, produced a match. Mr Henley KC found that all the actions taken by the CCRC during this third application were appropriate and necessary. Though we add, had the CCRC collaborated with Appeal earlier, as suggested by Mr Henley KC himself, these further inquiries would have not been necessary. So we believe that Mr Henley KC was too lenient in finding that the steps were necessary. They became necessary because of the CCRC failing to collaborate earlier. However, he also found, alarmingly he says, we would argue shockingly, that even at this stage, before the DNA match was produced, an entry was made in the case decision record detailing a meeting between the case review manager and the commissioner. This entry indicated the decision that short of a match on the DNA database of a viable person of interest, this issue could not form the basis of a referral of the case. This was particularly troubling given the Nealon's case and the past history of this case. It seems that despite improvements in casework quality, lessons from past cases had not been learned, says Mr Henley KC. For balance, we report that the CCRC countered this point, stating that this entry does not represent the final decision, which would have been determined by a committee. Nonetheless, says Mr Henley KC, it is extremely concerning that such a possibility was even considered. Also, we note that a single commissioner may make a decision not to refer a case. Therefore, there could have been a possibility that this case would have not gone to a committee, or at least this is our understanding. The CCRC, however, rejected the application concerning the non-disclosure issue. Mr Henley KC criticised this decision, which was later proven incorrect when the Court of Appeal found that the non-disclosure alone rendered the conviction unsafe. It is alarming to think that if Mr Malkinson had submitted his application based solely on these grounds, the CCRC might have missed yet another opportunity to refer his deserving case to the Court of Appeal. Mr Henley KC asserts that this demonstrates the CCRC's failure to apply the real possibility test, which should be understood to mean, says Mr Henley, that the Court of Appeal will quash the conviction if he concludes that the jury's verdict might have been different had they heard the new evidence due to its potential significance, thereby rendering the conviction unsafe. Now let's turn our attention to Mr Henley KC's views on the CCRC's decision not to obtain the police file. But before doing so, if you are finding this video interesting, like it and consider subscribing to our channel to help us in our mission to humanize wrongful convictions. Now, turning to the reasons for not obtaining the police file. From the file history, Mr Henley found that while the CCRC put the police on notice to preserve the file, a power recognized under Section 17 of the Criminal Appeal Act 1995, it did not in fact obtain the file, a power which is also provided by the same section of the Act. He was unable to find a clear and reasonable explanation in the case decision record for why the police file had not been obtained. In the absence of such an explanation, he concluded that the failure to secure the police file during the first application was likely related to the case review manager's lack of understanding regarding the significance of the new DNA test results, which were revealed by Operation Cube in 2007. Mr. Henley says, had the case review manager given the due consideration to this evolution of the DNA evidence, he would have understood that something must have gone wrong in the identification process and that securing and reviewing the police file was crucial to understand whether errors had occurred during the identification process. However, Mr. Henley found that the case review manager was not curious enough and also was too reliant on the Court of Appeal's finding in the first appeal that the identification evidence was compelling. This seems to have been taken by the case review manager as a given and undisputed fact and contributed to the case review manager failure to request the file and be curious about what might have gone wrong in the investigation stage and the identification process. So he concluded that the failure to chase the police file at this stage of the first application was mainly due to inefficiency and poor performance. As we know now, Mr Malkinson's appeal was allowed not only on the basis of the new DNA evidence, but also due to undisclosed material recovered from the police file, particularly photographs from the victim's hands and previous convictions of the witnesses who identified Mr Malkinson, which formed a separate ground of appeal. Therefore, the CCRC's failure to obtain the police file contributed to the delay in providing Mr Malkinson with the justice he deserved, as the undisclosed fact could have emerged much earlier during the initial application. The failure to obtain the police file during the second application is even more troubling, said Mr Henley KC, considering that this application identified specifically several breaches of PACE Code D, which concerns suspect identification. For instance, it noted the impropriety of transporting the victim and the witness together in the same vehicle to the police station for identification procedure, which could have risked influencing one another. Additionally, it highlighted that one of the identifying witnesses did not attend the identification procedure for 6 months, potentially compromising the reliability of the identification. The CCRC refused this application on the basis that though it did agree with the appeal that the breaches had occurred, these were explored at trial and were known to the jury. In fact, the delay in the identification by the second identifying witness was resubmitted on the first appeal in 2006 and dismissed by the Court of Appeal. Mr Henley KC found that the refusal was founded, and he was also impressed with the CCRC level and quality of work and found that each submission was carefully considered with an open mind approach. Nevertheless, he once again criticized the CCRC for failing to obtain the police file, given the sufficient concerns raised by appeal about the identification procedure. A careful consideration of the police file would have, in fact, as we know now, uncovered the failure to disclose the victim's hands photograph and the prior convictions of the identifier witnesses, factors which were ultimately deemed by the Court of Appeal sufficient on their own to render the conviction unsafe, and were in fact accepted as separate grounds of appeal. He also noted that the failure to request the police file was not just a matter of poor performance, but rather a more ingrained culture of reluctance to request police files, blindly assuming that all the investigation material is passed on to the CPS and that obtaining the CPS file would be sufficient. Ultimately, Mr Henley KC concluded that the police file should have been obtained from the outset. Indeed, he says in his summary, already during the first investigation, there were a series of issues which should have called for the contents of the police file to be examined. But certainly, it should have been obtained at the second application, when a range of issues were raised concerning breaches relating to the way the identification evidence was obtained. As per the criticisms and concerns raised in the media, we only briefly note that Mr Henley KC criticized the CCRC for not offering an immediate and unreserved apology to Mr Malkinson at the time of the appeal, acknowledging its serious shortcomings in handling the case. To make matter worse, he says, the CCRC should not have made public statements in August 2023 claiming full credit for the DNA retesting, the crucial work of which was actually carried out by appeal, not the CCRC, as well as for not addressing the non-disclosure of critical information that alone could have rendered the conviction unsafe. This material was all uncovered through appeal's diligent efforts, not the CCRC. As per Mr Henley's observations, learning points and recommendations, first, we wholeheartedly adopt his observation made at page 12 that this case exemplifies the fundamental importance of full and transparent pre-trial disclosure of all relevant material to the defense to ensure the integrity of the trial process. We also note at page 13 that he emphasizes and further articulates a point that we have consistently highlighted in our videos and described it as our mantra, namely that above all this case demonstrates a deep-seated, system-wide cultural reluctance which starts right at the top from the Court of Appeal to acknowledge our criminal justice system will on occasion make mistakes, that entirely innocent defendants will sometimes be convicted, and have this possibility at the forefront of our collective mind when trying and reviewing cases. This is no more than being faithful to the presumption of innocence, the guiding principle of our system of justice, which we all subscribe to. It is not by any standard a success or a demonstration that things are working properly that Mr Malkinson had to wait 20 years to be exonerated. As per Mr Henley's KC's recommendations, 9 in total, in short, these are as follows. Given the poor or lack of understanding of the DNA evidence on the part of the CCRC staff, the first 3 recommendations focus on a need to review all CCRC files where DNA evidence is involved. As we know, this review is now underway, and we discussed it in some detail in our June news session video, which you can find linked in the description below. He also recommends regular training for all CCRC staff to ensure that the test that should be applied to cases is understood. This is understood to be that a referral should be made when new evidence comes to light that, if known to the jury at the time of the trial, might have resulted in a different decision. Given that disclosure failures have been at the core of numerous miscarriages of justice, he also recommends that the police file must be obtained. And if not obtained, a clear and traceable account for this decision should be made in a clear entry within the case decision record. He further recommends that in future, following any decision not to refer a case, consideration should be given to whether any recommendations, action plans can be made to revisit the case to ascertain whether further work in future might result in a different decision being made. He also advises the CCRC to aim to be more collaborative with representatives of applicants. In addition, he recommends that group leaders should hold regular review meetings with their case review managers to ensure that progress is being made, to provide support and effective oversight of the work. However, in light of the fact that he observed a greater level of collaboration within the CCRC more recently, he recognizes that this recommendation may need little adjustment in the processes already in place. Finally, he emphasizes that the CCRC should be provided with more resources by the government. The publication of the review elicited several reactions, most notably that of Mr Malkinson and that of the new Justice Secretary Shabana Mahmood. Starting with Mr Malkinson, writing in The Guardian, he said that he would like to see some resignations, starting with Miss Pitcher. He adds that Pitcher and her discredited and incompetent senior leadership team should now be replaced with people with a track record of fighting injustice without fear or favour. Survivors of wrongful convictions like me and the post office operators should have input into the recruitment process. He concludes that while the police and the prosecution caused my wrongful conviction nightmare, the CCRC must take its share of the blame to needlessly prolonging it by more than a decade. The whole institution needs to be torn down and rebuilt. The most compelling point from Mr Malkinson is expressed halfway through the article, where he states, "The truth is that there is something deeply wrong at the CCRC and nothing less than a complete overhaul is needed." Proof of this comes from a discovery made by Henley that shook me to my core. The CCRC, he found, was contemplating rejecting my case for a third time in 2022. If that doesn't persuade the government that the CCRC is biased in favour of dismissing miscarriages of justice cases, rather than accepting that the police and prosecution may have got it wrong, I don't know what will. Mr Malkinson's calls for Pitcher's resignation were echoed by Shabana Mahmood. The Guardian reported on the 18th of July 2023 that the new Justice Secretary said that Pitcher is unfit to fulfill her duties and that she was seeking her removal in light of the findings. However, Pitcher's position was also reported in the same article and said to be that she had no intention of standing down, as she believes she's the best person for the job. Pitcher's stance can only be described as hubristic. To date, she remains the CCRC chairman. So should the CCRC, in Mr Malkinson's words, be turned down and completely rebuilt? Mr Henley's report on the CCRC provides a nuanced perspective on the organization's functioning and its evolution over time. Though extremely critical of the CCRC, he acknowledges significant improvements in the CCRC's operations, particularly noting the enhanced professionalism and depth in recent work. This suggests that the CCRC has made positive changes in response to past criticisms, leading to a more effective review process. Therefore, far from being the moribund body that most were expecting Mr Henley to depict. However, we have already mentioned that the scope of Mr Henley's report was limited to Mr Malkinson's case. So could this report on its own be realistically the answer as to whether an overhaul of the CCRC is needed? To address this issue, we must answer a crucial question. Is Mr Malkinson's case an isolated incident, or does it reflect the CCRC's overall conduct? According to Mr Henley KC himself, this does not appear to be the case. It is understood that he told The Guardian that it will be worryingly complacent simply to pass this off as an isolated case, indicating that this criticism may point to broader issues within the CCRC's wider caseload. If his criticisms were to apply to even a few more cases, given the limited number of cases referred, especially in the past few years, it becomes evident that nothing less than a complete overhaul of the CCRC would suffice. And what do you think? Let me know in the comments below. Another point worth mentioning relates to Mr Henley KC's concluding remarks, particularly paragraph 132, where he describes the CCRC's core mission and statutory purpose as to refer cases where new evidence comes to light which might have made a difference to the jury's verdict, and therefore the verdict can no longer be regarded as safe. This is also the test the Court of Appeal applies. First, there is a debate over whether Mr Henley KC has unduly restricted the criteria for referral, even considering the stringent real possibility test, since new evidence is just one of the grounds for questioning safety. Nonetheless, we consider this is the test that the Court of Appeal applies in practice, and in any event, this is an issue far too complex to fully address in a video like this. However, a point of disappointment that we would like to highlight was that Mr Henley's description of the core mission of the CCRC's core mission has been reduced only to the referral portion, neglecting another important statutory purpose of the CCRC, which is often cited alongside its role of referring cases to the Court of Appeal. This purpose involves the CCRC's authority to investigate and proactively lead inquiries into cases where an applicant persistently and consistently claims a miscarriage of justice has occurred. The current expectation and widespread approach within the legal profession that new evidence is needed before one can approach the CCRC undermines the CCRC intended role as an investigative body that proactively seeks out evidence in response to claims of wrongful convictions. As explained in our video Criminal Cases Review Commission Last Gasp of Survival, the Ransman Commission anticipated that the new body should not expect individuals who have suffered a miscarriage of justice and are in prison to clearly and coherently present their cases. It expected the new body to be adequately resourced to conduct interviews with applicants to determine whether their cases warrant investigation. The Commission also envisioned that the new body should have investigative powers to conduct its own investigations and to direct other entities to investigate on its behalf without being prompted by the applicant as to the grounds upon which the referral should be based. In other words, a certain degree of initiative in the direction of the investigation. Though Mr Henley KC alluded to this aspect of the CCRC in several parts of his report, such as when he found that the CCRC could have taken the opportunity during the second application by appeal to conduct further DNA testing, or when he criticized the case review manager for not taking the initiative to periodically review the case for potential future match after rejecting the first application, we believe he did not emphasize this aspect enough. The case of Mr Malkinson demonstrates that even at its best during the second and third applications, the CCRC tended to be reactive, merely responding to submissions included in the applications by either rebutting or adopting them as it sees fit. This suggests that the CCRC has drifted from its original vision over time. The CCRC was primarily tasked with investigating potential miscarriages of justice, and new evidence should not be a prerequisite for their involvement. Indeed, an ordinary citizen will not have the power to obtain the police file to unearth non-disclosure issues, and even more so when they are languishing in prison. The initial goal of the CCRC should be to review claims of wrongful convictions and seek out evidence that support that. Finally, does the reluctance and unwillingness of former CCRC staff members and other key decision makers to meet and speak with Mr Henley KC reopens the question as to whether Mr Malkinson's public inquiry should be now made statutory? Although this might compromise time and flexibility, particularly with the ongoing investigation into the new suspect, which would significantly delay such an inquiry, this compromise might be worthwhile to achieve the best results and provide Mr Malkinson with the answer he so desperately needs to move on with his life. This is especially important considering the immense suffering Mr Malkinson has endured and given the post-traumatic stress disorder he will have to live with for the rest of his life. And what do you think? Should Mr Malkinson's inquiry be made statutory? Let us know in the comments below. I hope you found this analysis interesting, and if so, do like this video and subscribe to our channel if you have not done so already, to assist us with our mission to humanize wrongful convictions. Also, join our networking hub at spokeninjustice.net to have your say as to the future content of this channel. Join us again as we sit and rise in this unique trial.